I'm Laura Williams, and this is PwC's Tax Insights in Brief. The U.S. District Court for the District of Colorado recently issued its opinion in the case of Liberty Global versus the United States. In his order on cross motions for summary judgment, Judge Jackson ruled in favor of the government. At issue was whether the economic substance doctrine was relevant to the taxpayer's four-step transaction dubbed Project Soy. Economic substance was added to the Internal Revenue Code as Section 77010 in 2010 and provided that when relevant, a transaction has economic substance only if the transaction changes in a meaningful way the taxpayer's economic position and the taxpayer has a substantial business purpose for entering into the transaction. Project Soy was a 2018 transaction in which Liberty Global sold a foreign subsidiary of its U.S. group to its foreign parent, in a transaction that would later be defined by the Treasury Department in regulations as an extraordinary reduction. Prior to the sale, the taxpayer engaged in three internal transactions: the capitalization of its target for non-qualified preferred stock, the restructuring of a subsidiary with intercompany debt, and the conversion of a foreign subsidiary from a Belgian BVBA to a Belgian NV. The combination of these steps with the sale of the subsidiary caused gain recognized by Liberty Global to be recharacterized as a dividend, for which a full dividends received deduction was available. The government argued that the court should disregard the first three transactions of Project Soy because they lacked economic substance. And doing so would mean that the taxpayer would not receive dividend treatment on its gain and therefore could not offset such gain with a deduction. The government's argument focused on its view that the taxpayer achieved a tax benefit that was unintended by Congress through a structured and tax-motivated transaction. Liberty Global stipulated that it failed to meet the two prongs of the economic substance statute, but argued that economic substance was not relevant to its transaction on the basis that the steps were basic business transactions for which economic substance should not apply. Relying heavily on the case of Gregory v. Helvering, a 1935 U.S. Supreme Court case, Judge Jackson concluded that the economic substance doctrine was relevant to Project Soy because the taxpayer had obtained a benefit that was unintended by Congress in a transaction that failed to satisfy the two-pronged test of the statute. The court further concluded that it was appropriate to consider the first three steps of the four-step transaction together, as opposed to analyzing just a single step. And in doing so, concluded that the aggregated steps did not qualify for an exception for basic business transactions, as provided in the legislative history of Section 77010. This case impacts taxpayers in the District of Colorado. Liberty Global has said they plan to appeal the decision in the 10th Circuit. For more details, read the attached insight. Thank you for watching. This has been PwC's Tax Insights in Brief.